Hi, everybody, and welcome to the Expert Witness Show. I am your host, David Smith, and today we wanted to talk about how experts, while trying to be helpful, can sometimes go too far and end up hurting both the case they're working on and their own credibility, and how to see that and discourage them from doing that. So today's episode is brought to you by Alpine Engineering and Design, your first call for mechanical engineering expert witness services. So this was a case that I worked on a couple of years ago, and in this case, a truck driver was found unconscious on the ground next to his trailer with serious head injuries that had lasting repercussions. And the difficult part about the case is that nobody witnessed the accident. Nobody saw how the driver was injured, and everybody's accounts of the events surrounding the accident were different. And to top that off, the truck driver that was injured had no recollection of the events that surrounded the accident. So in spite of this lack of information, the plaintiff's expert, I was working for one of the defendants, but the plaintiff's expert made several definitive claims about the only way the injuries could have happened, supposedly in an effort to help the case. But instead of helping in the end, because his claims were so outrageous, the expert's claims were easy to see through and easy to rebut, and really ended up hurting not only the case, but his own reputation and his credibility. So to start this off, the expert had made an assumption that while the trailer was being unloaded, a pallet fell over and either knocked the driver off of his trailer, causing his injuries, or caused him to leap out of the way off of his trailer, which resulted in his injuries. And he was so set on these being the only possibilities of how the accident occurred that it really just destroyed any credibility that he might have had going into this. Now, for example, he was asked during a deposition, was there any possibility that the truck driver just slipped and fell off of the trailer? And he answered negative, that no, there was absolutely no way that this happened any way other than being knocked off or him jumping off. And his only rationale for him not slipping or tripping or falling off of his trailer was that he's a truck driver and he's always up on his trailer. He's very familiar with it. So he wouldn't have just fallen off. And, it sounds a little bit ridiculous because it is. OSHA statistics show that, nearly 25% of recorded accidents are typically slip, trip, and falls type of accidents. There's also, I was able to find several articles from trucking-specific publications that stated that half or nearly half of all injuries to truck drivers were due to slips, trips, and falls. So this argument that he wouldn't slip off the top of his trailer, or off, it was a flatbed, so he wouldn't slip off of this trailer bed that was, 4.5, 5 feet in the air, because he's a truck driver and he's very familiar with it, just really doesn't hold any water. And because the expert stuck to that opinion so fervently, it ruined any credibility for any of the other arguments that he made. Because it is entirely possible that he just slipped and fell, or he tripped on a pallet or any of the tie downs or other things that were up on the trailer. He made a couple of other claims that were sort of outrageous. So one of the other ones is that he said that the forklift operator was negligent and failed to abide by OSHA regulations. One of those being that trucks shall not be driven up to anyone standing in front of a bench or other fixed object. And this one really doesn't make sense. So this was a soft-sided trailer, so it had a cover and those covers rolled up on either side so that you could get access to the trailer and remove the materials. And there were two posts. There were two posts, one on each end, and two posts in the middle. So the trailer was broken into thirds on each side. And what it seemed like this expert was saying was that the forklift operator was negligent because the truck driver was in between the load that the forklift was picking up and one of these posts, which doesn't make a lot of sense. First thing, the truck driver fell off the opposite side of the trailer as where the materials were being picked up. So he wouldn't have been really between anything. The materials would have been moving in the opposite direction of where he fell off. And the next thing is that if he was in a position where the forklift operator was driving up to the truck driver, with the truck driver being between the forklift and a fixed object, he would have had to have been hanging out over the side of the trailer in front of one of these posts. And that would be a dangerous position independent of whether or not there was any forklift operation going on. So if that were the case, then the operator had put himself in a dangerous position that he never ever should have been in anyway. So again, that argument didn't hold up either, and this expert was firm that that was something that had been done wrong in this case. And as a third example, he said that there was another forklift policy that had been disregarded or broken, and that only loads within the rated capacity of the truck should be handled. Now this one is still somewhat puzzling to me because for some reason he thinks that lifting a load, and there's no evidence that this ever happened, by the way, but for some reason that trying to lift a load above the rated capacity caused this truck driver to fall off the other side of his trailer. And that it doesn't really seem to add up, but these were the opinions that he had. And so we were able to go through and, show or testify that, there's really no evidence to support this. He didn't do any testing. He didn't have the weights of any of the loads. He didn't even know the capacity of the forklift. The OSHA inspector that went out and did this inspection before there was the lawsuit said that the forklift was in good working order, and it didn't appear that anything had been lifted over the capacity. And so, he'd gone out on these limbs, and by doing that, absolutely destroyed any hope of a case that they had, and they ended up dropping this case because there was just nowhere to go with it based on what their expert had said. So for experts, when you're evaluating a case, please be honest and forthright with the attorneys so that they know what their risk exposure on a case is. You don't want to lead them on a case thinking that they have a slam dunk knockdown, absolutely we're going to win this case, when really you have no good arguments at all. And in that same vein, when you realize that there may be some areas where there may be some facts that are not the most helpful to your side of the case, by bringing those up and discussing them beforehand, you can know what your risk exposure is, and you can also work together to figure out the best way to handle that situation when those questions come up. And for attorneys, most attorneys are really good about this, but there are some that push experts to give certain opinions, and when they do, it typically ends up being the outcome of that ends up being one that is undesirable. So stick to the facts, stick to things that you know, and don't go so far out on a limb with things that are really unsupportable just to try and win the case, because experts are not hired to win cases. Experts are hired to provide opinions on and inform the judge and jury on what would be proper, what the laws are, and what typical design standards are. So don't go above and beyond trying to win the case. That's not what you're hired for. And when you do, you end up not only hurting your case, but your own credibility. So stick with what you know, stick with what you can back up and testify to, and everything will work out in the end. Thank you for watching, and we'll talk to you next week.